Welcome back to Central Valley Business. I am Mike Briggs, and our next guest is, of course, I took my glasses off, Sherrie Flynn from Coleman Horowitt, the law firm, and you're a patent attorney. I don't think we've ever had a patent attorney on any of our shows.
That's probably because there aren't very many patent attorneys in Fresno.
It's quite a specialty, though.
It is quite a specialty. In fact, I had to take the bar exam, and then I had to take a separate bar exam for the patent.
And that's why there's not a lot of them around.
That's correct.
It's a lot of extra work. Who would need a patent attorney?
Startup companies, individual inventors that have ideas that they want to protect would need a patent attorney. Somebody invents something new and useful, and they don't want everyone else to just jump on the bandwagon and use and make their invention. They need a patent attorney to help them protect that.
Protect it. Some people think they could protect it by themselves, maybe by going to some online website or something like that.
Well, there is the USPTO website, and an individual inventor can file their own patent application themselves, but the patent office has their own special language. I call it patentees.
Yep.
And it's very difficult for an individual inventor to negotiate all the rules and the language necessary to actually patent something.
Now, will that be different than a copyright, like somebody writes a book or composes some music?
Yes, that is quite a bit different. A copyright protects the actual work of authorship, the tangible writing or music, and that is, in comparison to patents, a lot easier to obtain copyright protection.
So we have a lot of people on our shows who built something or invented something. Now they're trying to market it, and this is a good place to start marketing something because it's free or really cheap to do that. And they put labels on. They built custom containers. They're putting a lot of money into it, but without the proper protection, somebody with more money could come along and just steal their idea.
That's correct. That's correct. And you mentioned things like labels and containers. You can also protect the container, like a trade dress, like a Coca-Cola bottle is the trade dress of Coca-Cola.
Nobody else can do that.
No one else can.
Because it's patented somehow.
Well, that itself is a trade dress. That's a separate type of protection, but it's intellectual property. The Coca-Cola formula itself is a trade secret, which is also a form of intellectual property, but it is actually not patented. Coca-Cola keeps that as a trade secret. You mentioned labels. You can protect a logo or a phrase, or, for example, the name Coca-Cola. You can protect that as a trademark. So there's a lot of different aspects of intellectual property.
I'd imagine it would be easy to invent something, start putting it out there, and even if you think you patented it yourself, you may not have the ability to protect yourself.
That's correct. When you file for a patent application, you submit to the patent office a set of claims. And when it comes down to protecting the invention, it's all about the claims. So if someone else tries to make your invention, if they make an invention that's exactly what you claimed, then it's patent infringement.
So you have to make the proper claims.
Correct.
Now, those of us who've never made a claim or written a patent or written a claim, we probably have less expertise at it than, say, somebody who does it all the time.
Correct, correct. It's very important to use the proper language to get the claims as broad as you can get them so that you cover as much as you can of the invention. And
I would imagine when you're doing the patent and making the claims, you're thinking, how can I defend this? Or prosecute, would you call it defended or prosecuted? I don't know, somebody stole your client's claim.
Yeah, actually, prosecution is the term of actually getting the patent itself. So it's a little different than normal litigation. Prosecution means you have an interchange with the patent office to get the patent. Basically, if somebody is infringing your patent, you may want to file a patent infringement action. So you would be a plaintiff in a litigation.
You'd be the plaintiff. So the patent attorney is probably setting up for that. I mean, if somebody's got a good idea, somebody's going to try to steal it or copy it or kind of copy it.
Correct, correct. So when I'm writing claims for a patent application, I'm thinking about how broad they are, the exact wording I'm using. If I ever have to defend basically the patent, the validity of the patent itself, or claim that someone else is infringing it, I want those claims written correctly.
Now, one of my favorite shows on television, I don't know if you've seen it, Silicon Valley.
I actually have not.
It's on HBO or one of those. But they're in Silicon Valley inventing software and programs and stuff like that. I would imagine that would need a patent as well.
Software can be patented under certain conditions, and it also can be given copyright protection. You can copyright the code itself. Right now, in the practice of patents, software patents are harder to obtain. The Supreme Court came down with a case decision recently, and it kind of changed the face of software and business method patents. So they're more difficult to obtain, but you can still get them. But it takes an experienced patent attorney to know how to obtain that type of patent.
We had a gentleman in the other day, and he has invented a spray-on lubricant. Similar, it kind of does a similar thing to what WD-40 does, but it's much better because it's water-based, et cetera, oil-based, I forget which it is. But would he want to get a patent before he goes out with that?
He very well may. I mean, in terms of patenting, what you need to consider is, do you want to patent something or do you want to keep it as a trade secret? And a lot of times, if someone can reverse engineer something, then you want to patent it. But when you patent it, you disclose in the patent application the invention. And the protection only lasts a certain period of time.
And in your Coca-Cola example, they didn't disclose.
They didn't disclose, and they actually take great pains to make sure that nobody can figure out that formulation for Coca-Cola.
And if somebody did and they presented totally differently, they can get away with that.
They can. A trade secret is only as good as the secret itself. If it's a secret, it's a trade secret. Once it gets out, anybody can do it. Unlike a patent, you have to disclose to the patent office the invention. But for a period of time, basically 17 years, plus or minus, for a period of time, you get exclusive rights to keep other people from making or using your invention. So even though it's disclosed, other people can't make it or use it.
But after 17 years, it's wide open?
It's basically wide open. So that's the consideration. Coca-Cola, for example, has been around for 100-plus years, and they've kept that trade secret that long. So trade secrets, as long as they're a secret, you can keep them forever.
I've wondered why. I've seen some products that all of a sudden explode. They're from different companies. I say, why now are all these companies doing this? It must be at the end of the 17 years.
Correct. It's at the end of their patent rights.
I spend a lot of time thinking about this stuff. But at the grocery store, I get a little squeeze bottle. You squeeze a little flavor into a bottle of water. Now, every company, just in the last 3 or 4 months, every different company is making those. And that might have been the issue.
That might have been the issue.
Somebody hit the end of the road.
Yeah, the patent rights may have expired. I mean, generic drugs versus the original drug, that's what happens there. The patent expires, and then anyone can make or use it.
So if there's a really popular drug, or you say maybe after 17 years, the price might really drop because it becomes more generic.
Correct.
A generic version.
Correct.
And so I guess you would by then want to have built up your name identity and built a good name. Bayer aspirin. I guess aspirin is probably aspirin, but why do we buy Bayer? Because we're more familiar with it.
Right. And see, Bayer itself, it could be a trademark. It is a trademark, I'm sure, of the Bayer Corporation.
Right.
And so trademark is another aspect. Like Coca-Cola, like Bayer, you might want to trademark and protect the name itself as well as the invention that it protects.
So now watching this show, I'm sure there's dozens or hundreds or thousands of people watch you. They have an idea. They're just afraid to bring it out because they don't want anybody to find out about it before them. So is it recommended that those people go and talk to a patent attorney before they do anything?
Yes. Before they do anything, they want to talk to a patent attorney. If they talk to someone and disclose their idea, a couple of things happen. Number one, they expose themselves as somebody just taking that idea from them. And the other thing is the patent, the amount of time they have to file a patent starts to run. Basically, once you disclose an idea, you have a year to file a patent application. If you don't file in that year, it's forever in the public domain. So you don't really want to start that clock running if you don't have to, and you sure don't want to tell your idea to someone who might try to take it from you.
And how do you know the patent attorney will not steal your idea?
Patent attorneys, as other attorneys, are under a obligation of confidentiality. So even if we're not in a attorney-client relationship, if you come to me and you disclose your idea, I still am under obligation of confidentiality. I cannot tell anyone your idea.
So the person you should talk to then is the patent attorney.
Correct.
Instead of your brother-in-law or your uncle or
Correct.
something like that, because you have some built-in protections.
Correct.
Now, have people come to you and you said, do you go do a patent search to see if there's anybody else doing it?
Sometimes yes, sometimes no. It depends. Patents are expensive. And so sometimes it makes sense to do the search. Sometimes the search could be as expensive as just filing the patent.
I see.
Once you file the patent application, the United States Patent and Trademark Office is going to do the search for you.
They do the search for you.
And they're going to tell you what other art is out there
Okay.
that might preempt your invention. So sometimes it makes sense, sometimes it doesn't. It just depends. And one thing I recommend to individual inventors that are trying to save costs is they can go on the USPTO website and they can do a search.
PTO.
And yes, it's the USPTO, U.S. Patent and Trademark Office. And they can do the search themselves, and at least then we can sit down and talk and they can tell me what they've found, and we can kind of go from there.
Now, have people come to you and said, that idea is just too crazy, I don't want to take your money?
Not so much crazy, because I'll tell you what, there's a lot of crazy ideas that get patented. But people will come to me and I'll see that their invention is obvious.
Mm-hmm.
An invention's got to be novel.
Right.
It's got to be new. No one else has to have the exact thing, but also has to be unobvious.
Mm-hmm.
And if I see that it's obvious, then I won't take their money. I'll just tell them no. As it sits right now, your invention, I don't believe would be patentable, and it's probably not a good idea for you to spend the money.
But it probably would not hurt to call a patent attorney. Let's find out. I mean, you got an idea in your head, and you want it to be your idea, and you think this could be the thing that changes your life and the lives of other people, I guess. You'd probably be pretty safe to go talk to a patent attorney.
Yes, and I usually, if someone calls in and wants to talk to me about patents and what it takes to get a patent, I'm happy to talk to them on the phone without billing them. If it seems like the relationship might work, that they might have a real need for a patent attorney, I'll do a consultation too. They can come in our office. I'll sit down with them for a half hour or so, look at their invention, talk to them about the patent process, and not bill them. And then if they decide they want to go forward with a patent application, then we can enter into an attorney-client
And then they know what it's going to cost them and what the process
Correct.
is going to be. Now, I visited a local pump company. It's been 10 years ago, but they were always inventing a new kind of pump, I guess, and getting patents. So it's not just the entrepreneur off the street coming in. Sometimes there's a corporate patent.
Yes, absolutely. And there's quite a number of corporations around the valley and companies around the valley that have multiple patents.
And they always need to be patenting their next new item.
Correct, because most patents are the invention is built on an existing invention, but it's a new improvement to that invention. So something like a pump company, they're always coming up with a new seal or a new casting for the.
So it could be a small thing. It doesn't have to be a giant.
No, it does not have to be a giant. It could be a small thing.
Okay, very good. Did I leave anything out? The signal is go. I can talk about this for hours. Bill knows me. I'll go on and on and on. I love this kind of stuff.
I think we covered the basics at least.
How can they reach you? We have it on the screen, I think.
Yes, it's ch-law.com is our website. My email address is sflynn, SFLYNN, at ch-law.com, or they can call our office, 559-248-4820.
And if they just get to the website, they'll be able to find your
They'll
email
be able
there.
to find me, the email address there, yes.
Or call us here at Central Valley Talk. If you've got a patent, call us, and I'll give you Sherrie's phone number. Sherrie Flynn.
Correct.
From Coleman and Horowitt Law Firm, right over on, is it on Shaw?
It's on Shaw Avenue on the south side of Shaw, real close to Fig Garden Village.
If you live in Fig Garden, you could walk there and get your patent protected.
Absolutely.
So thank you for coming.
All right.
We'll be back with more Central Valley business right after this.